Hello everyone, and welcome to our Stratford webinar, Litigating Parental Alienation Claims, Strategies, Investigation, Obtaining Evidence, Role of Experts, Intervention. Before we turn this over to our presenters, we want to cover some basic housekeeping information. First, like all Stratford webinars, the presentation will be followed by a Q&A session. Please submit questions to our panel at any time using the Q&A box located on your screen. Also, for those of you seeking continuing education credit, you must verify your participation in this webinar by responding to the attendance verification prompts that will pop up on your screen throughout the webinar. At the end of the webinar, you'll be given an opportunity to complete the certification process by clicking the link that appears on your screen. If you do not click on that link following the webinar, you will receive an email with the link to complete the certification process within 24 hours. For those listening as a group, please know that at the end of the program, you'll be shown the code you need to enter on your group listening form. We've gathered a panel to discuss the issue of allegations of supposed parental alienation and other guidance for handling a case involving such allegations in court. The panel will discuss the term parental alienation, why it is controversial, how to defend against the claim of parental alienation in cases involving allegations of child abuse, how to litigate alleged matters where the resist-refuse dynamic presents itself, the role of a child's attorney or guardian ad litem, and practical strategies for obtaining and admitting evidence to prove or defend against such allegations. Our panel today includes Kirk Stange, founding partner at Stange Law Firm. As always, the views expressed during today's webinar are those of the speakers, not of Stratford, the speaker's firm, or clients, and are not intended to provide legal or tax advice. I will now turn it over to our speakers.
All right, welcome everybody. Appreciate you all being here. Definitely an interesting topic, and we'll go ahead and jump on into the materials here. All right, so we'll begin with the topic of developing a strategy to prove parental alienation. Obviously, in order to do that, you have to understand what the definition of parental alienation is. I think a lot of lawyers get it. I think some lawyers can be confused. So let's give you the textbook definition. A child who expresses freely and persistently unreasonable negative feelings and beliefs such as hatred, anger, rejection, and/or fear toward a parent that are significantly disproportionate to the child's actual experience with that parent. And so I think a couple of the key words you want to focus on here is unreasonable, disproportionate. Okay, so we'll get into this in some slides coming up. We're not talking about the situation where a child has a reasonable reason to not want to be around one of their parents. We're talking unreasonable reasons that don't make sense, that are disproportionate to the facts and the circumstances, right? So unreasonable is kind of that key phrase you want to keep in mind. Look, alienation can occur both at the time of divorce or during a fight over custody. So it could take place, during the divorce proceedings. It could take place after the divorce proceedings began, and for some individuals, it could be after the divorce is concluded. Of course, alienation can also occur in child custody cases involving parents that were never married, so it can be common in those cases too. Individuals can have various motives for alienation, including revenge, right? They're upset with the ex, the other parent. Could be a power situation where they want to be in control. They might have fear of the other parent. In theory, it could be jealousy. And unfortunately, it can be a situation a lot where we're dealing with significant mental illness. So it could be a situation where a party doesn't even know they're doing it, that they're alienating the kids, but they're suffering from a mental health disability that makes it hard for them to recognize what it is that they're doing. All right, so look, three main elements of parental alienation syndrome, if you want to kind of break it down in a technical sense. All right, one is rejection and denigration of a parent that reaches a level of a campaign, right? Look, I mean, some individuals might say some things that are unkind about the other parent here or there. Again, not good. Parents shouldn't do that. But we're talking a campaign, like a repeated thing. It's not just an occasional negative comment. We're talking repeated, regular comments to the kids that aren't good about the other parent, okay? The rejection is irrational, okay? Not a reasonable response to the alienated parent's behavior. So, look, some parents can behave in a manner that isn't nice to the kids, that maybe in some circumstances, unfortunately, could be abusive, whether it be verbally or physically, so the kids don't want to be around them. Okay, that would be a reasonable response in circumstances of abuse, but we're talking unreasonable again, irrational. Okay, and then three, it's a partial result of the non-alienated parent's influence. So for there to be alienation, there has to be the other parent involved in this, right? Typically, the other parent on a campaign of some kind to alienate the kids um, from their ex or the other parent or whatnot, right? So if the other parent's behaving appropriately, then it's not alienation. It's got to be a circumstance where the parent's behavior is a cause. All right, so from a textbook definition, in order for there to be parental alienation syndrome, all three of these elements need to be there, right? And if they're not, then it's probably not alienation. It could be something else tragic, but not alienation. All right, Gardner's 8 symptoms of child alienation of the child. So just sort of 8 symptoms you might see that ultimately can help create a circumstance where a lawyer or a judge or court or guardian ad litem says this is alienation. Okay, so denigration of the targeted parent completely, especially in the presence of the alienating parent. So the one parent saying terrible, horrible, dastardly things about the other parent in front of the kids so the kids can hear it. Okay, weak and irrational rationalization for the denigration, right? So there's not anything there. I mean, nobody's a perfect parent, right? Nobody behaves wonderfully at all times, but there's not a rational basis for the one parent to just detest the other parent to such a degree. All right, lack of ambivalence in making the denigrating statements, right? I mean, just making the statements freely, recklessly, carelessly, if you will, no real thought or concern about the statements in the comments and the denigrating of the targeting parent, right? There's none of that there, right? No real remorse for what's taken place. All right. The independent thinker phenomenon. The child proudly professes that his or her rejection of the targeted parent is their own doing. So look, lots of times the kids will say, "Nah, look, I don't want to be around my mom. I don't want to be around my dad." You know, they'll be open about saying it. If you do enough family law cases, there'll be cases with, the argument is, well, the kids wouldn't get in the car to go with the other parent. What do you want us to do? The kids refuse to go over there. What do you want us to do? There's nothing we can do here, right? And oftentimes, parents who don't comply with court custody orders and get held in contempt, that's the argument. It's like, well, I told my son or daughter to go, but they don't want to go. They don't want to, and if they don't want to, I'm not going to make them. Kind of argument, all right? But we're looking at the kids being very open and making comments and statements that I don't want to see my mom or dad. I don't want to. All right, reflective support of the alienating parent. So then the alienating parent, when the kid says, I don't want to go see my mom or dad, or I don't like my mom or dad, or I don't want to have a relationship with their mom or dad, an alienating parent is going to typically support that and reinforce it and say, yeah, look, if you don't want to go, you don't have to go. If you don't like your mom or you don't like your dad, you don't like them. You don't have to like them. So this reinforcing behavior, which I think we all know as family law attorneys, parents shouldn't do. But in the case of alienation, this is what the alienating parent does. They might even make comments like, look, you're old enough to decide whether you want to see your mom or dad or not, right? So if you don't want to go, you don't want to go, right? So you're looking for that kind of behavior. No guilt or remorse over the exploitation of the targeted parent. Okay, so look, I mean, typically, people get divorced. Okay, they're not going to be together as a couple, but most reasonable, rational people understand the kids still need to see the other parent. But in a case of alienation, there's almost no guilt or remorse. If the kids don't go, the kids don't spend time with the other parent, right? The parent who's engaging in the alienating behavior there's no feeling bad about it, no remorse, nothing like that. All right, look for the presence of borrowed or rehearsed scenarios. I mean, I've seen this in multiple cases through the years where the kids come in and it's the unfortunate circumstances. I know judges don't typically want kids to testify, but I've had some cases where it's happened and the kids come in and they almost parrot stuff. Like it sounds like they're just saying things that they rehearsed before they came in. Looks like something almost fed to them to say. Um, I remember one time doing a custody case, and the kid came in, and without even any prompting, without even being asked a question that had anything to do with this, the kid just said, "Look, I drove in the car last week with my dad, and he was drunk." Right? Of course, the dad vehemently denied that he did it, and when you got into the details of it, I don't think he did it, right? But the kids come in and they just say things. They parrot things. They're told what to say. It's almost like they have a bug in their ear, and the alienating parents telling the kid what to say. So look for that kind of stuff. Canned statements, canned responses, and again, the technical term for that is parroting. It's like a parrot hears people speak and then just repeats it, right? That's what alienated kids can do sometimes. They just parrot something that they've been told to say or that they heard their parents say about the other parent, and it's literally just like a parrot, like a canned response. All right, animosity toward the extended family of the alienated parents. Oftentimes, they don't want to see the aunts, the uncles, the grandparents, the cousins, anybody, right? So that's not uncommon in circumstances of alienation. Okay, so all things to look for. All things to look for, and the more those you have, the more likely there is alienation taking place. All right, additional symptoms that you can look for that might point toward alienation would be showing a blatant disregard for the parent and the parent's feelings. Like most kids don't want to hurt their parents. I mean, likewise, most good parents don't want to hurt their kids, right? Nobody wants to do that. But in a case of alienation, the kids don't care, or at least they don't seem to care if they're upsetting their mom or dad by not going over there. Uses adult language. Again, look for the parroted comments, the just sort of blurting out of things. Again, in court, a kid could come into court if they're testifying and blurt it out. If any of you are guardian ad litems and you interview kids, if the kids are just blurting stuff out, they're using adult language, it doesn't make sense. That could show alienation. All right, mimics, demeans, and disrespects the parent that they don't want to see or be around. Right, makes fun of them. Dislike spending time with the parent, right? Most kids want to spend time with both their parents, but in these circumstances, the kids don't want to spend time with the parent. Again, they refuse to go, right? Or they go and they're calling the other parent saying they don't want to be there, come pick me up, these kinds of things. In extreme circumstances, a kid could run off to try to get to the other parent's house, something like that. All right, overprotective of the other parent, right? So the parent who's doing the alienating, the kids, right, are overprotective of them. In some ways, I think most kids could be asked by a guardian ad litem or a judge, well, what do you like about your mom? What don't you like? What don't you like about your mom? What do you like about your dad? What don't you like about your dad? Most kids, hopefully they're saying more things they like than dislike about their parent, these kinds of things. But I think most kids, if pressed, would have some critique of their parent. I mean, that's common. But in the case of alienation, the one parent who's doing the alienating, there's probably not going to be anything they don't like. There's probably going to be no critique of that parent. All right, so they believe the alienating parent is perfect. They're perfect. They do no wrong. And it could be a circumstance where they blame the other parent, the non-alienating parent, for the divorce or the breakup of the relationship or whatever the circumstance is, and so that can be very, very common. That's how the kids feel and communicate. All right, so let's talk about the alienating parent. All right, so this is the parent engaging in the bad behavior, doing what they shouldn't be doing. All right, so some of the things that these parents, some of their characteristics might be, they allow and insist that the child make decisions about contact. So they'll say that, as I said earlier, hey, look, you're old enough. If you don't want to go to your mom's or you don't want to go to your dad's, you don't have to go, this kind of thing. And I've seen many of these kinds of circumstances where the kids refuse to go. The other parent files a motion for contempt, and the one parent says, hey, what do you want me to do? Can't make the kids go. I can't push them in the car. If they don't want to go, they don't want to go. All right. So oftentimes they refuse to hear positive comments about the rejected parent and quickly discounts good times as trivial and unimportant. So look, most parents, even after divorce, even after a custody case, even if they don't really particularly care for the other parent, right, they just don't care for them. Most of them enjoy hearing that the kids had a good time with their mom or their dad or whatnot. But an alienating parent just disregards it all. It's all bad. All right, no encouragement of calls to the other parent in between visits, and rationalizes that the child doesn't act, doesn't want to take these calls, right? Most parents, again, they can have some hard feelings toward the other parent, but they're going to encourage the kids to get on the phone, speak to the other parent. They're not going to engage in behavior to stand in between that, but the alienating parent will do this. All right, sets few limits or is rigid about routines, rules, and expectations. Oftentimes, the alienating parents, like the good time parent, the fun time parent, no rules, no curfews. You can do this, you can do that, all these different things. And again, the reasoning behind it is sort of subtly they want the kids to be with them because they're the fun parent. There's no rules, there's no regulations. You don't have to do your homework over here. You can stay out all night. Don't you want to live with me, kind of thing, right? Trying to curry favor with the kids by letting the kids do what they want to do. All right. Refuses to speak directly to the other parent. I mean, look, sometimes, speaking to the other parent, this is going to be tough. This is going to be difficult. More and more parents using, applications like Our Family Wizard or Talking Parents or something like that. Maybe they've been court ordered. So we're not talking about circumstances where parents are told to use these apps or court ordered to use these apps. But oftentimes they'll just refuse in any circumstance to speak to the other parent, maybe even in the case of emergency. Refuses to be in the same room or close proximity, and does not let the target parent come to the door and pick up the child. Okay, body language and nonverbal communication reveals disinterest, disdain, and disapproval. The rejected parent discourages or refuses permission to attend school events and activities, or does not believe that the child has any need for a relationship with the other parent. Again, most parents, after going through a divorce or custody case, I mean, some cases amicable, some not, but even in cases where it wasn't amicable, most good parents realize the kids need a relationship with both their parents. But in the case of an alienating parent, they probably don't recognize this. All right. Look, in cases where parental alienation is a possibility, obviously a party is going to need a lawyer to help investigate the case, do discovery. It's going to be critical in terms of proving these cases. The preferred parent will likely be attempting to influence the opinion of the child, so an evaluation to determine what's the child's emotional state can be critical, whether loyalty conflicts exist. Whether the child has a strong desire to please one parent over the other, let's say, or whether the child has a lot of anger toward one parent. And again, we'll get into this in some slides coming up. It's not uncommon, obviously, that kids after divorce or custody case, the kids have some anger and some resentment. But the question is, again, is it just targeted at one parent, or are they a little bit upset with both? Which is very common. And then you get into, again, is it reasonable? Is it or is it irrational? And those are sort of big diverges in the road. And typically in the case of alienation, the alienated parent has not done dastardly things. They're probably actually a decent parent who cares, but the kids have been alienated from them. It's up to the lawyer to really broach the possibility of parental coercion. So look, you got a client and they're saying the kids don't want to come, the kids don't want to see me, the kids don't talk to me. Again, as a lawyer, this ought to trigger, not definitively that there's alienation, but it ought to trigger the possibility that alienation could be there. All right, and obviously, to get the keywords parental alienation in a judgment, that can take a lot. And so, to get a judge to make that finding is typically going to require proof, and that is going to be critical in terms of proving that to court. And we'll get into this a little bit more coming up too, but to get that in a judgment, it's often useful to have an expert, like a psychologist, come in and testify in a custody evaluation that parental alienation occurred. If not, judge might find bad behavior, that the parent did some things that they shouldn't do. But to get the term parental alienation in a court finding typically requires some proof. And so it's going to require some proof of parent bashing, brainwashing, these kinds of things, inappropriate comments made to the kids. And again, not that the parent messed up once or twice, but we're talking a campaign, as we talked about before, that the other parent is on a campaign to really bash the other parent. All right. Assessing children in high conflict custody cases is important to determine whether the child is non-alienated or likely alienated if they align with one parent and show signs of visitation, refusal, or certain beliefs about the other parent that are likely distorted. So again, one of the paths you want to go down again is, are the kids' beliefs about the parent that they don't want to see or talk to, are they rational or are they irrational? Are they justified or are they unjustified? And you should know there's a term called realistic estrangement, okay, that's out there. And from my vantage point, talked to a lot of attorneys when I use this term. They're like, I don't know what that is. I've never heard of that. Well, you should know that's the opposite of parental alienation. So when the kids don't want to see one of the parents and they don't want to be around them, they don't want to talk to them, then the question is there parental alienation or is there realistic estrangement? Okay, realistic estrangement is the opposite of parental alienation, and this is where a parent's behavior is so outrageous, so abusive, that the kids are estranged from them. Like the kids don't want to be around them anymore. And it's not irrational, it's rational. It's not unjustified, it's justified because it maybe it's been physical abuse, emotional abuse. There's been a long pattern of it, and now the kids don't want to go. And so this is where, out of the gates, from my vantage point in dealing with lots of these cases, out of the gates, it's hard to know. Is there alienation here? Is this parent actually a good parent who's been sort of smeared by the other parent over the course of time and like a campaign? So there's parental alienation. Or do the kids not want to be around that parent because the parent's behavior is outrageous? It's terrible. And no reasonable kid would want to be around a parent that behaves in such a manner. So that is $1 million question in these cases out of the gates. And you can't just automatically assume that it's alienation. It could be a circumstance where the parents have really behaved poorly in a really dastardly manner, and that's why the kids don't want to be around them, okay? So this is where it's much more complex, okay? So look, to give you some more detail on alienated kids and some symptoms you could look for in alienated kids, maybe a lack of cohesive sense of self-care, okay? Enmeshment, when the alienating parent's emotions escalate, the child's emotions do as well. So mom gets really upset, the kids get really upset. Dad gets really upset, the kids get really upset. Like the kids mimic the parent's behavior, or their emotions, I should say. Adoption of the preferred parent's thoughts and feelings on most things, or just about all things. Oftentimes the kids have poor reality testing, in that they have this viewpoint of one of their parents that's really distorted, that doesn't make sense. But they've convinced themselves of it, like they actually believe it, right? And that becomes part of the problem. And the longer it goes on, the worse this can be. And it could be hard to help a kid if they've had these, they've been alienated over a long period of time, okay? Illogical cognitive operations that don't make a lot of sense could be there too. All right, so objections or options to test the child for alienated symptoms. Psychological testing is oftentimes used as part of a custody evaluation to determine whether the child is acting alienated because of actual experience with an odd preferred parent, or because of the preferred parent's actions. All right, so again, you get to the circumstance where it's just a basis of, is it outrageous behavior of the one parent where the kids don't want to be there, or the kid's been alienated, and that's a critical question. All right, in terms of case strategy to prove alienation and litigating a case, a parent who has been alienated from their child by the other parent, getting the case to court is extremely important. Putting on the full evidence can be a huge key. If the full evidence isn't on, it can be hard to prove that. Oftentimes you're talking about witness testimony, counseling records, psychological records, all these different things can really help support it. Without it, oftentimes judges may gloss over some of this stuff and not know how bad it actually is. Toxic parenting can spread quickly, much more quickly than it normally takes a case to make it through the court process. And so oftentimes getting the case heard as quickly as possible to try to diffuse the alienation can be an important thing. Obviously, a parent who's being alienated, this could be tough stuff, and oftentimes it can be really hard for them to sort of cope, to make it through. But encouraging clients to do the best they can to maintain some sort of form of contact with the kids can be a key, despite whatever anger or scorn exists. I mean, the truth is, the longer a child is kept away from a parent, the harder it can become to overcome the distance later on. Lots of parents automatically assume that if they prove alienation exists, for example, that means they're automatically going to get custody. It's important to let clients know that isn't always the case. I mean, in some circumstances, the kids could be so alienated from them that it's hard to put the kids back with them. So getting to court quickly, filing the necessary case and motions and progressing a case can be a huge key. All right, it's also important to ensure that the non-preferred parent does not begin to act inappropriately after the alienation has started, because the poor behavior could be used to classify the child's behavior as a rational reaction to the non-preferred parent. So look, it's tough when kids don't want to see a parent, and if you're a parent sitting in those shoes, that can hurt and that can sting. But the last thing a parent wants to do in this circumstance is to start lashing out at the kids, getting angry at the kids, getting mad, getting into verbal confrontations with them. Why don't you want to be around me? I've been a good parent, blah, blah, blah. Your mom's just saying X, Y, and Z to you to upset you. Like, oftentimes doing this stuff can make it worse. And then versus being it labeled alienation, it could be deemed realistic estrangement. All right. It's also imperative to secure a detailed order for parent-child contact that has penalties for non-compliance instilled in them, right? So we all know, as divorce and family law attorneys, you get that temporary custody order. Lots of states refer to it as a pedente light order, where you get temporary custody established, and then if the other party doesn't comply, you move for sanctions. Some jurisdictions like Missouri, where I predominantly practice, you can file what's called a family access motion, let's say, to exercise the visitation and to enforce it. So again, counsel can ask on a pedente light basis to order consistent contact between the non-preferred parent and the kids, and again, do that as soon as possible. And then some of the most common violations that a court will likely deem are against the best interest of the child include refusing to respect visitation rights, taking the child without the other parent's knowledge, and then bad-mouthing the other parent. I mean, most parenting plans or custody orders have some language that says that this isn't to occur, that parents aren't supposed to speak negatively about the other parent in the presence of the kids and whatnot. So having that in there can be good. And then again, I can tell you, I've just seen it over and over and over again. In cases of alienation, the kids may refuse to go. The kids just won't do it. And so you need some language in the judgment that protects against this as much as possible. And obviously, there should be language, if possible, in there that says, the parents will encourage the kids to see the other parent and whatnot, to make sure that, again, parents aren't going down this path of just saying, well, if the kids don't want to go, I can't make them. Very common in parental alienation cases. When there are allegations of undue influence by the parent during the parenting time, then a parent can ask the court for a no contact order during the non-preference designated time. Again, ensure that the sanctions are included for situations of non-compliance. Again, this would be in rare cases, but certainly in cases of parental alienation, this is a possibility. And also having other protective language in there, could be good as well, including not scheduling activities during the other parent's custody time or appointments during the other parent's custody time. I mean, oftentimes an alienating parent will do these kinds of things, try to muddy up the other parent's custody time with a bunch of appointments and stuff that they didn't consent to, which really diminishes or ruins their time to spend, ruins their ability to spend time with the kids. All right. Cases involving parental alienation that aren't routine can be a key thing to have expert testimony to really buttress this. I mean, that can be huge in these cases. So finding a custody evaluation or therapist familiar with parental alienation can be big in establishing parental alienation. From my vantage point, for a judge to make a finding of parental alienation, I mean, maybe this isn't the viewpoint of every judge out there, but I think a lot of judges would want a custody evaluator to find parental alienation before they do. They might find again that a parent has behaved badly, they've behaved poorly, but it's hard to make it, quote, alienation without the opinion of an expert witness. So having a mental health expert early on to really establish the symptoms that we've gone through and the dangers of parental alienation to the court can be key. Again, you all have to know the judge that you're litigating your case in front of. I mean, a lot of judges did family law before they went on the bench, so they get this, they've seen it, they understand it. But a lot of circumstances, the judge could have been doing criminal law or civil litigation. They get appointed, they get put on the family court, and they haven't seen this stuff firsthand. So having an expert witness can be key in terms of finding parental alienation. Then again, past that, if it exists, what's in the best interest of the kids here? And it isn't an automatic deal where once you prove alienation, it means your client wins custody. No, not at all. It could be that the alienation's so bad that just throwing the kids with a non-alienating parent and cutting the alienating parent off, that could result in the kids not doing well at all, right? Running away, suicide risk, these kinds of things. And so it's much more complex than just saying, oh, okay, we prove alienation, my client gets custody. It's not that simple. Not that simple at all. All right, so again, the most important part of proving parental alienation is you've got to establish that the child's rejection of their parent is unjustified, okay? They're unjustified. And so as a lawyer representing an individual in one of these cases, you should examine the child's complaints about the non-preferred parent to determine are they exaggerated or are they disproportionate to the degree of the children's animosity or fear. I mean, I've seen these cases where they're just absurd allegations that on its face, you think, is that even possible? Is it possible that this individual would do that? And if it's just highly exaggerated, highly disproportionate, highly unbelievable, for example, take situations where, say, a kid says they were physically abused by their parent, but then immediately afterward, there's no signs, there's no marks, there's no bruises, right? There's just nothing there to show that this actually occurred. I mean, those are the things as a lawyer you want to look at. If kid says they were physically abused and there's bruises and broken bones and, these kinds of things, you can substantiate that this probably happened. But I've seen cases where there's just constant allegations of physical abuse, but then there's no bruises, there's no bumps, there's just nothing there. So these are things you want to look at. And again, whether the non-preferred parent's behavior would be harmful to the children if the parents were still together. So again, you want to look at the non-preferred parent, and oftentimes, if there's really alienation, these parents are probably pretty good. They've just been alienated. Okay. All right. So here's some case examples for you to try to, just help you all picture this if you haven't, seen this firsthand in cases. Give you some of the leading cases out there on this topic. So we got Hillkirk versus Johnson. Case out of Louisiana. Here, the trial court found that the level of parental alienation startling, even stating it was appalled when the minor child sat next to the mental health expert to discuss the case and stated she would only spend time with father to prevent mother from going to jail. In this case, the trial court ordered a custody change from mother to father and would not allow mother to contact the child for 2 months. Again, that's allow for the reestablishment of the relationship. We've mentioned this before, that no contact order kind of thing seems extreme, but it can happen in these cases. Here, the appeals court determined that while there was evidence of parental alienation, it was not enough to change custody. The appeals court focused heavily on the best interest of the child and could not find in the record clear and convincing evidence that the advantages of the change in custody would substantially outweigh the harm likely to be caused to the child because of the change. And so for this reason, while parental alienation existed in this case, it occurred, it was not enough to establish that the best interest of the child would be met by the child being removed from the alienating parent. So again, be careful. Just because you proved alienation doesn't mean your client wins. It still comes down to, well, what's in the best interest of the kids in light of the circumstances. And this is where a mental health expert, typically a psychologist, through a custody evaluation, can create a report that is, thoroughly addresses what's in the best interest of the kids. Okay, so that's typically what is needed. Okay, Wolt versus Wolt out of North Dakota. Here, the court awarded custody to mother, even though 2 of the 3 kids strongly favored father. Father, among other things, had been abusive to mother, involved the children in the divorce, and undermined mother's parenting and told the children bad things about mom. And so in this case, a party who willfully alienates a child could not be granted custody based on that alienation. So here, opposite result. But again, it all comes down to the facts. Okay, you got alienation, but again, then what's in the best interest of the kids? Totally different deal. Okay, another case example, Martin versus Martin. Here, father's petition to modify custody order was denied because in considering the child's testimony, it seemed inaccurate and unreliable, as if the child had memorized a list of complaints, was under pressure to make sure the court heard the entire list. Again, this is kind of a parroting example, right? The kid comes in like a parrot, says things they've been told. It's unnatural. It's not organic. It's not in response to questions. That ought to stick out if you're a lawyer or guardian ad litem or a judge, and you ought to think, this doesn't seem right. Looks like the kid was coached to say these things. All right, very important to distinguish that. And then we have Ellis versus Ellis, another case example where here daughter was determined to suffer from parental alienation syndrome. The mother was deemed the major cause of that alienation. In this case, experts found an excessive dependency on the mother to the child. That child suffered depression and a dip in social skills due to this. The court also found that the alienation went beyond just father, but also father's family. We referenced this earlier. Oftentimes, alienated kids don't want to see the whole extended family, including the child's grandparents, aunts, uncles. The court found that the issue did not only concern custody, but child's overall emotional health, and that mother's actions were beyond the realm of reasonable behavior and contrary to the best interest of the child. Custody in this case was altered in favor of father due to the alienation. So here, there's alienation, but the court gives custody to father, right? So sometimes proving alienation can result in a favorable custody result, but sometimes it doesn't when it's not in the best interest of the kid. So again, got to be able to make that distinction. All right, CGL versus MWB. Here, the trial court awarded father sole physical custody of 3 kids due to testimony by a mental health professional that found mother was alienating children from father, even if she was possibly doing it unintentionally. Okay, we talked about this at the beginning. Sometimes alienating parents have mental health issues. Okay, that could be the case. And in some of these circumstances, a parent might alienate and they might not even recognize that they're doing it. Okay, sometimes they know what they're doing and it's very purposeful. But sometimes, and I've seen this, parents doing it and they don't even have insight in it. They don't realize it. Okay, so here the appeals court would not rely on the term parental alienation syndrome, but stated that mother had attempted to alienate the children from their father. So again, splitting hairs. We don't think there's parental alienation syndrome, but mother engaged in behavior that was alienating like. And more specifically, the mother had repeatedly demonstrated she was unable to promote father's role in the children's life, right? Just couldn't say good things about dad. Just couldn't do it. Because father would promote the children's relationship with mother, but mother would not promote the relationship with father. Father's award of custody was affirmed. So again, courts typically like it when a parent is able to say positive things about the other parent, promote the other parent, even if they don't really personally care for them after divorce or custody case. But a good and decent parent is going to keep that to themselves and say positive things about the other parent to the kids at all times. All right, Beggins versus Beggins. The court would not reward father's continual poisoning of the children against mother with a grant of custody. Right. So again, another example of individual alienating, so he doesn't get custody as a result. Again, just trying to give you some case examples so you can visualize this, so you can see this. Every fact, circumstance of these kinds of cases can be a little bit different, and it can change the pendulum in terms of the outcome. All right. So here we have Hansen versus Spolnick. Here, father argued that mother had engaged in a pattern of parental alienation with child that was affecting child's long-term emotional and physical needs. The child psychologist determined that mother's comments and allegations against father were directed at alienating child from father, and that mother's behavior endangered child's emotional and psychological development. In this case, the court agreed that mother had engaged in a concerted effort. Again, we used the term campaign before, campaign, concerted effort. You can see we're driving home a similar theme, but there was a concerted effort to destroy child's relationship with father since a divorce. And for this reason, the court awarded father sole physical and sole legal custody of the kids. Also, mother was denied visitation for a period of 60 days, followed by only 2 hours of supervised visitation with the child every 2 weeks for 3 months. So in this case, mother penalized quite heavily. And again, father given a 60-day period of time with the kids, and then mother's got to work her way back in. So pretty harsh punishment there. All right, but again, you got to look at what's in the best interest of the kids in every specific case, and certainly reasonable judges and courts can disagree. So the result's not always specific. But one of the things, and we'll talk about this, a little more coming up, that I just want to keep driving home is expert testimony. I mean, you see in these cases, you really need expert testimony, okay? Typically a psychologist, somebody with a PhD, and somebody who's done custody evaluations in the past is typically what you're going to need in order to prove alienation. Without it, you might be able to prove some of the symptoms, some of the factors pointing to alienation. You might be able to prove alienating behavior, but to get a, quote, finding of parental alienation, you typically need expert testimony. All right, facing false abuse allegations head on. So a parent who's been falsely accused of dastardly things. So often when a parent goes far enough to attempt to alienate a parent from the child, that parent will also have no problem leveling abuse claims at the other parent, right? And I kind of alluded to that earlier. One parent says the other parent's physically abusing the kids, but there's no bruises, there's no broken bones, right? There's no physical evidence to support that or substantiate it. Very common in alienation cases, and it could be the kids. Go so far as to say one of their parents was abusing them when they weren't, unfortunately, all right? So involved in a custody dispute, a parent may present these false symptoms to another parent in an attempt to even the playing field in getting custody of the kids, or is an attempt to gain favor over the other parent. These abuse allegations can include sex offenses. I hate to say it, but I've seen these cases where one parent is falsely accused of sexually abusing the kids, let's say, dastardly, but it can happen in these cases. Physical and emotional abuse, criminal offenses, drug abuse, domestic violence, other negligent behavior. Take the example I gave at the beginning where the kid just comes to the court and says, yeah, last week Dad drove in the pickup truck with me drunk. Guy swears he did no such thing, right? So wasn't arrested, didn't get a DWI, so very hard to prove one way or the other, but he says he didn't do it. So these allegations can come in parental alienation cases. For sure they can come. So defeating these claims can be time-consuming, costly, oftentimes requiring both an investigation, litigation. Oftentimes a parent who's alleged to have done this, they're going to have legal and expert fees necessary to prove that no abuse occurred. So oftentimes you need a custody evaluator. When a parent is accused of abuse, it will be easy for that parent to tell anyone that will listen that he or she is not an abuser and that the allegations are clearly false. But you all know the way these things can go. Oftentimes people don't believe it. Oftentimes, people believe what they hear, even if it isn't true. And sometimes too, maybe a guardian ad litem is kind of out of the gates inclined to believe it. And so this is where, taking these allegations and trying to refute them head on is important. So look, but once accused, it can be hard for simple words to convince someone from Child Protective Services or, Division of Family Services, whatever it's called in your jurisdiction. Oftentimes CPS, DFS, a prosecutor, police officer, GAL, or judge, oftentimes might be predisposed to believe these things when they hear them. So it's important to ensure that the client doesn't speak, if they're being accused of these dastardly things, obviously don't speak to the police, the prosecutor, or anyone else involved in the case without an attorney present. If it's Child Protective Services or Division of Family Services, whatever it's called in your jurisdiction, if they want to interview your client about some kind of abuse allegations, you want to be there to protect your client, right? So you want to be there, and sometimes maybe your client doesn't need to speak to them at all, and so you don't have them speak. But don't send your client in there alone to speak to these different agencies or whatnot. Very dangerous. You want to be there as an attorney, just to make sure your client's being treated fairly. All right. Again, declarations of innocence are not likely to convince anyone on its face. So in some cases, it might be better not to say anything. That would typically be the case. Let's say if the police wants to interview your client or something like that, maybe they don't speak. And again, it's going to depend on the facts. This is going to depend on the circumstances, and certainly if they're going to speak, your client typically needs you there if you're their attorney, or maybe a criminal defense attorney as a co-counsel there with them. All right. So steps to take after an accusation has been made include, again, it's always important to remain steadfast in your client's innocence. I mean, obviously, if your client's telling you they didn't do it, it's your job and duty as an attorney is to stand by them. Obviously, we've all had clients who were more believable and less believable, and more credible to us and less credible, but obviously it's our job to represent them. Obviously, if trying to get custody or visitation immediately, even if supervised visitation is a big key. So that can be huge. Maybe sometimes the visitation's been cut off through a child order protection, restraining order or something like that. So trying to get some kind of visitation quick can be a big key. And supervised visitation isn't fun, but that's oftentimes better than no visitation, right? That way the parent and the kids still having a relationship, all right? Having your client log all key events in a calendar or diary can be a big key. Oftentimes, people forget what happened 6 months ago, a year ago, these kinds of things. Maybe some clients don't remember a month ago what happened on a specific date. So keeping some kind of calendar or diary of key events can be a huge thing. For sure. All right. Do not allow the client to attempt to poison the child against the other parent, even though the other parent has made terrible accusations against your client. So you always got to tell your client, look, they might be right. They might be hidden below the belt. They might be saying dastardly things about you to the kids and whatnot. But this isn't a time to get down the mud with them. Take the high road with your kids. Say nice things about the other parent. And you just have to hope and fate and destiny and that good prevails over evil and that, things are going to work out in the end, right? So make sure your client doesn't fight fire with fire, get in the mud with the other party, maintain the high road. And you have to, ensure your client has optimism and faith that again, ultimately the judge or the guardian ad litem is going to do the right thing in the case. All right, allow the client to talk to the child regarding the issue without placing blame. Encourage the client to remind the child of the good times the other parent has had with the child and share family stories, and encourage the client to continue showing their love and constancy to the child even if the child does not want to accept it, right? So kids have been alienated. You gotta, the way to fight that is through love. Kids have been told bad things about your client. You got to tell your client the way to fight that is through love and affection, not getting in the mud with the other parent. All right, that's the counterbalance is showing love and care and affection toward the kids, and ultimately that's the best. It's the best way to counteract the alienating behavior. It's not fighting fire with fire or anything like that. Another difficulty that arises with child abuse claims is that children can easily be led in a child's testimony, even memory can be contaminated, right? So kids testifying in court can be troublesome, can be difficult. I mean, most judges don't want it, but unfortunately, in cases of parental alienation, sometimes it occurs. Now, it might occur in camera with the judge, with the parents outside the courtroom or something like that. But it can oftentimes happen. Know as well that this is another one of the advantages of a custody evaluation because, if there's a custody evaluator who's a PhD, child psychology, let's say, and they've done these reports, and, they can talk to the kids outside of the courtroom in a more informal setting. And if you have a custody evaluator that you trust, that you think is good, who's honest and forthright, then they can, in their report, indicate the kid's feelings and thoughts and details that the kids have, and their viewpoints and these different things, and put them in the report to such a degree that sometimes the kid's testimony isn't needed because it's all in that report. Okay. So a lawyer should demand an early discovery of all videotapes, audio tapes, and transcripts of interviews with the accuser. This way, an attorney can determine if the accusation is coming directly from the other parent. Using experts, again, very beneficial and helpful because an expert can find indications that coercion has taken place. Oftentimes, the kids might divulge that their mom or dad told them to say these things, that their mom or dad said X, Y, and Z about the other parent, these kinds of things. And these experts will also be able to explain the suggestibility of the children and the possibility of memory distortion. Right, so kids that have been alienated, they can take an event and then make it 1,000 times worse than it actually was. For example, right? It's distorted. The memory's distorted because they haven't, they're alienated. So their perception of their one parent, the parent who's been alienated, isn't good. So they'll distort something, blow something out of proportion. But look, in a lot of cases, it is possible to beat a false abuse claim, false allegations. But as an attorney, you got to be diligent, you got to be competent in order to do that. So let me give you some examples. We've got Handrahan versus Malenko, case out of Maine. Here, a forensic evaluation team fit the case into the moderate evidence of sexual assault category and used evidence such as consistency and specificity of the child's statements about the abuse. The court noted that the investigators did not, however, account for the factors weakening the likelihood of abuse, like the age of the child, his inability to recall surrounding details, the fact that this assertion was made in the middle of a custody dispute, and that he had been questioned previously about abuse. So that's one example there. Noland Vance versus Vance, case out of Missouri. In this case, mother asserted that the trial court erred in awarding sole physical and sole legal custody of three of the 6 kids to father. When mother filed for divorce in this case in June of 2005, she alleged that father abused her as well as the kids. Based on evidence and witness testimony, the trial court found that both mother and father, they abused each other. However, the trial court found that the allegations of abuse toward the kids was unsubstantiated. It wasn't credible. The clinical psychologist, again, these folks become key in these cases. The clinical psychologist who performed the court-ordered psychological evaluations found that this was the worst case of parental alienation he had ever seen. During the evals, the psychologist opined that because mother did in fact suffer domestic abuse, she sincerely believed that the father posed a danger to the kids too. And so this belief led mother to emotionally abuse the children by alienating their affections from father. Mother admitted that she never said anything positive about dad in front of the kids, so it was all negative stuff that she said. By berating father in front of the children, incitement, that this incited fear of father to the kids, and her constant negativity toward father, mother caused children to suffer severe trauma. The psychologist found that the parental alienation one child suffered was so extreme that the relationship with her father was likely irreparable, couldn't be fixed. And so again, the longer this goes on, the harder it is to undo it. Because mother's behavior caused such severe parental alienation, father's contact with the children would be problematic, according to the psychologist. The guardian ad litem supported the psychologist's findings and testified that the children were severely traumatized by parental alienation syndrome and not because of any physical abuse from father. The Court of Appeals found that the trial court did not err in the award of sole physical and sole legal custody to father in this particular case, right? So that's definitely an interesting case out of Missouri. And again, the distinction there, you can draw, which isn't always the case, but I mean, just, when there's abuse, let's say there's abuse between the parties, it doesn't necessarily mean there's been abuse of the kids too. Or to put it another way, just because a party would abuse their spouse, it doesn't mean they would abuse the kids. I mean, some folks, their anger gets directed in one way versus the other. I mean, sometimes there can be great overlap there, but in this case, the court found no overlap. So definitely interesting case. Lauren R. versus Ted R. Here, mother and father were awarded joint legal custody. However, mother made many decisions without father's input, and enrolling one child in private school, and repeatedly interfered with father's visitation. In this case, the record was replete with numerous instances of alienation caused by mother against father, including threats of punishment to the children for wanting to spend time with the father, father's deprivation of time with the children during Hanukkah, and repeated instances of father being advised of decisions after the fact, which caused resentment between the kids and father if father did not consent to the decisions, right? So mom making these decisions, and then father would be put in the position of having to try to undo them after the fact, which would be difficult. To top it off, mother accused father of sexual abuse. Again, I hate to say this, but in these parental alienation cases, allegations of sexual abuse can be commonplace. Maybe sometimes they're true, but oftentimes they're not. Here, mother testified that one of the kids told her she felt uncomfortable when father tickled her. Mother attempted to report this abuse to Child Protective Services and encouraged the child to inform her pediatrician that father inappropriately touched her. The pediatrician, however, saw no signs of abuse. I mean, it's just tickling. After advising the children's prior psychologists and family friends of the allegations, the County Department of Social Services opened an investigation. Complaint was repeatedly made that father inappropriately fondled the 13-year-old, making her feel uncomfortable. When the caseworkers interviewed the 13-year-old, she denied the allegations that their father followed her and that father only tickled her on the neck and under her arms. So the child's not, the child's kind of walking it back. According to the child, father did not attempt to make her feel uncomfortable. The investigation was closed, but when mother met with the CPS caseworker, she once again alleged that father did it again. The caseworker warned mom not to bring the children into her disputes with the defendant, and said the warning was contained in the CPS records. So CPS even getting tired of mom here bringing these allegations. In this case, the extensive record of mother's behavior and complete disregard of the court's order of parental access / joint custody facilitated the court's decision to incarcerate mother for contempt. So again, very rare, but in theory, if it's so bad, that's a possibility. All right, so that's sort of a case on the extreme. All right, the next section we have up is identifying witnesses that will strengthen the case. So this can definitely be important. So again, the most important piece about parental alienation, again, is establishing that the child's rejection is unjustified versus justified. Again, sometimes it's justified, but you got to show that it's unjustified. So it's important as a lawyer that you examine the complaints of the kids or the non-preferred parent. The complaints of the kids about the non-preferred parent to determine whether they're exaggerated, disproportionate, these kinds of things, and then finding witnesses that could note a change in the child's behavior and attitudes, including relatives, friends, teachers, coaches, maybe even through videotapes and cards, maybe even email, text, message, evidence, these kinds of things to help establish a new and unjust disdain for the non-preferred parent. So again, all these different people could be potential witnesses, things to think about. Obviously, these would be lay witnesses, so these individuals couldn't testify as an expert that parental alienation has occurred here, but they could present details and facts that could maybe help influence the custody evaluator, maybe the judge, maybe the guardian ad litem, if you will. So it's definitely important to talk about all potential witnesses that may be out there. That can be a huge key. And again, we've talked about this a little bit, but obviously in custody disputes, it's important to have experts. Experts can be a big key. These experts may testify as to the custody evaluations of either the parent or the child, the substance abuse allegations if those exist. They may bring in psychologists, counselors, physicians, or other medical professionals. Oftentimes they want these records. The GAL, or the guardian ad litem, may have an opinion on whether parental alienation has occurred, but again, keep in mind, GALs are typically just attorneys, not mental health experts, and oftentimes, they're really not qualified to make this kind of expert opinion. All right, so it's important to keep that in mind. You need a CUS evaluator. In physical abuse cases, a physician could be useful, forensic pathologist or hospital pediatrician would be best in terms of finding any discrepancies between an explanation and an actual injury. In sex abuse cases, psychologists or therapists will likely be necessary to determine whether or not sexual abuse occurred or not. This can be tough, very tough to prove. I mean, I remember one case I had, an individual in a custody case had to undergo what's called a psychosexual evaluation to determine whether or not he had a propensity to be a sexual abuser. Social workers can also be important in these kinds of cases as well. And we talked about, CPS or DFS and these kinds of things, but these individuals can come into court and oftentimes provide helpful testimony. All right. Again, lay witnesses can be important, but it's important to remember lay witnesses cannot give expert opinion. But some lay witnesses to think about, again, neighbors, friends, relatives, teachers, coaches, scout leaders, maybe babysitters, people who are around the kids a lot. Oftentimes, lay witnesses may not want to engage in litigation, though. So it's usually helpful to inform the witness that he or she is only being asked to provide the court with objective information. Like they're not coming in to, quote, take a side, let's say. Oftentimes they're just testifying about what they've seen and heard themselves. Teachers or school counselors can be important in these kinds of cases. Oftentimes they have information about abuse or neglect. Maybe they've documented these things. Maybe they've seen bumps and bruises on the kids. Maybe the kids have complained to them about acts of abuse or something like that. Teachers or school counselors can provide objective information about things like hygiene, attire, alertness, even absences from school. They can also be useful in other ways as well in terms of being able to testify about grades and academics and these kinds of things. But you have to know oftentimes they don't want to testify because they don't want to be torn between the parents. They might feel like it's hard to be the teacher after they've come into court and testify or whatnot. So you got to be careful there. Obviously, these kinds of witnesses can't speculate. They can't give opinion-based testimony. But they can provide important information that can be useful to the court from a factual standpoint. All right? All right, next section we have up is structuring your approach based on the age of the child. All right, the age of a child can be crucial in terms of assessing the alienating behaviors that might exist. For example, children under the age of 6 tend to exhibit loyalty to whichever parent they are in, the physical presence of at the moment, while those over 7 years often form stronger alignments toward one parent or not. So looking at the age differences can be huge. Because the tendency increases once a child reaches adolescence, children between the ages of 12 and 18 may exhibit unjustified animosity and negativity towards a parent without the presence of alienating behaviors by an alienating parent. So sometimes teenagers can just have strong preferences toward one parent. They might have some animosity. It doesn't necessarily mean that there's alienation taking place. So keep that in mind. It's also important to note that because of cognitive developments, children younger than age 7 or 8 years old seldom demonstrate rigidly alienated behaviors. So, the younger they are, the better the chance of trying to remedy a situation where maybe alienation has begun or started to take place. Younger children more often forget their scripts, which we talked about before, parroting. And so if they come into court and they try to, say something that sounds scripted, it can be really easy to kind of pick it out. The older the kids, the tougher it is. The most common age range of an alienated child is 9 to 15 years. However, older children as well as some young adults can also be alienated. So again, 9 to 15 is where it's much easier for a child to be alienated, and it can become quite a bit more difficult to undo it. So when interviewing a young child, let the child do what they feel is comfortable during the interview, such as playing on the floor. And this would be if you were guardian ad litem or something like that. Obviously, if you're an attorney for one of the parties, you're not going to be interviewing the kids. But if you're a GAL, you're interviewing the kids. Obviously, let the kids feel comfortable. When interviewing the child, attorneys should focus on building a rapport with the child, inviting narrative answers, and should avoid putting pressure on the kids. Again, we're speaking mainly about GALs here. It's important to use clear-cut language with children. Making a child guess will lead to untrustworthy information. Asking open-ended questions like, how does your mom or dad get mad? Or is there anything anybody told you to tell me? Or is there anything you want to tell me? That can be good. Open-ended questions. Again, as attorneys, I mean, you might have to interview a child in court if they're being brought in to testify. Again, I know most judges don't like it, but I've had to interview a good chunk of kids in court, and obviously, you're kind of in a way for the most part meeting these kids really for the first time. Because again, if there's a guardian ad litem, the guardian ad litem's talking to them, you're not, you're representing one of the parties. But open-ended questions are typically what you want if you lead them. Not very good, not very persuasive. All right, next section. So again, open-ended questions if you have to interview a child. What, where, when, why, how. Don't lead them. Make them feel comfortable. Try to build a rapport. All right, next up we have using a custody evaluator to prove, disprove alienation. We've kind of gone through this a little bit, but again, a custody evaluator can determine, is this parental alienation, is this realistic estrangement, or is there none of it? I had one case a long time ago, I never forgot, where it was found that a party did both. So it's possible that both occurred. The parent alienates, but the other parent's really pretty bad and does things to estrange as well. So it's possible it can actually be both. Again, the difference is an estranged child, they don't want to be around their parent for real reasons, right? Repeated violence or explosive outbursts of a parent during the marriage or after separation, or who were themselves a target of violence and abusive behavior from the parent, right? Whereas the alienated parent has almost no history of physical, emotional abuse of the kids. The child's grossly negative views and feelings of the rejected parent is significantly distorted and exaggerated reactions. So you have to be able to differentiate between the two, and a custody evaluator is almost always going to help in these situations, okay? Again, many child custody cases turn on this issue about why the children might be more aligned with one parent or the other. Alienation, estrangement, is there none of it? Just teenagers who like one parent more than the other? Facts are going to carry the day, but you have to have a custody evaluation to try to help delineate between these different possibilities. It's hard as attorneys to do it without their help, okay? The proper method is to provide several names and should suggest that there are others who the parent may find acceptable as well. This allows the parent to make a decision that may affect their life and not feel like they're being exploited. It's important to know that some judges may not want a custody evaluation and may want to rely on a guardian ad litem only. I've seen this many times where the judges just don't want to do custody evaluations. They don't like it. They just want to rely on the guardian ad litem and their perceptions and opinions. And if that's what they want to do, that's what they want to do. Check the case law and statutes in your jurisdiction. But from my vantage point, these can be very helpful in these complex cases because it's not easy to really decipher between the two. It's also important to distinguish between an alienated child, again, one simply allied with the other parent. So an allied child simply expresses a preference for a parent during the marriage or after separation. It only wants limited contact with the other parent, but the allied child does not seek to terminate all contact with the other parent, right? They just like the one better than the other. Okay, that's not alienation. It can be hard to differentiate, but an alienated child doesn't want to go at all, right? At all. The biggest concern is ultimately how to make the child feel loved, and so the issue of what arrangement in child-parent custody care can best provide a child with a feeling of love is essential, and the core factors should be really assessed in every custody case. And certainly, if your client is not the preferred parent, Again, I said this before, they're not the preferred parent, but there's not alienation, or even if there is alienation, the way to combat it is with love and affection toward the kids. Lots of love, affection, and care. And hopefully, the hope is that the kids will eventually see that. All right, case example, AAB versus ADL. After years of stating putative father was a biological father of the child and playing an active role in the upbringing of the child, mother in 2015 said father was not the biological father, which DNA testing confirmed. Once this information was revealed to putative father, mother denied visitation and interfered with any of his court-ordered custody time. The GAL recommended that the court award sole physical custody to the putative father, who was not the biological father, because she had considerable concerns that the child was coached in terms of the testimony, because the child's testimony mirrored language used by mother and the biological father in text and voicemails. Again, parroting. This is that parroting going on, mirrored parroting, saying the same thing. And two, the biological father and mother's behavior was similar to that found in parental alienation. And three, she had concerns about mother's credibility. The GAL further testified that she had doubts as whether such behavior would end unless putative father was granted custody of the child. And so ultimately, in weighing this whole circumstance, the trial court found that mother had interfered with the putative father's significant bond and relationship with the minor child, and deliberately tried to destroy the bond between the putative father and the child without any recognition of possible serious emotional harm to the minor child. And because of this, the grant of sole physical custody to the putative father was affirmed on appeal. Obviously, in some states, you might go down a rabbit hole if not the biological father. Maybe this isn't possible, but that's the result of this case. LJS versus FRS. Here, the court-appointed therapist testified the child was not afraid of father, wanted to see father, had no negative comments to say about father. Therapist further testified that any negative feelings the child had toward the father were in fact mother's feelings, and she shared these with the child. It was the transfer of feelings from mother to daughter, which caused the therapist to be concerned about the potential for parental alienation syndrome. And so despite not diagnosing the child with parental alienation syndrome, the therapist found that if mother's behavior was not kept in check, that diagnosis may change. And so based on this testimony, the GAL's testimony, and all the other evidence in the case, the evidence that mother and father could build a better relationship, the Court of Appeals affirmed the trial court's grant of joint legal custody in this case. So sometimes there could be parental alienation, but custody turns out joint. Here they thought there was evidence it could get better. All right. Obtaining social media text and email evidence is the next section I have up. I don't know if we need to do the code. Would this be the time for the code?
Thank you, speakers, for your insights today. As a reminder for those of you listening as a group, the group listening code is on your screen. Oh, it will be. Group listening code is on your screen. This is required for your group listening form. For audio-only attendees, the listening code to obtain CLE credits for the live version of the CLE webinar is TFKFLH. That's T as in Tango, F as in Foxtrot, K as in Kilo, F as in Foxtrot, L as in Lima, H as in Hotel. Again, TFKFLH. If you have any questions, you may submit your questions by typing into the Q&A box located on your screen. Back to you.
Okay. All right. So here we go. Let me get back to the right slide here. All right, so social media text and email evidence. Again, this can be important in these kinds of cases in order to prove that alienation has existed. So be thinking about this. There could be emails and texts and social media posts that point to parental alienation. So you got to be thinking about it. Case example we have is in re marriage at Patterson. Here, Father challenged the district court's award of sole physical custody of one child to mother. The district court that father was on a significant campaign to alienate the children from mother. Again, campaign. This is a common theme we've been driving, not just a mess up here or there, a campaign. Father repeatedly criticized mother, engaging in slander and denigrated mother, and this behavior encouraged the same disrespect of mother. Father also made use of social media to attack mother, where the children could not only view the attacks, but could participate by liking and commenting, which obviously is a big problem. On social media, father discussed the inadequacies of the case, calling mother offensive names, and also posted sexually explicit photos of mother, all of which the children could see. In text message to the children, father commented to call mother offensive names and supported children's use of derogatory names for mother on social media. In this case, father's actions were against the best interests of the child, and the decision in this case was affirmed on appeal. And then we have this lay liquor case, another interesting case. Here, the district court did not abuse its discretion in allowing, in this case, Gottlieb to testify as an expert witness on the issue of parental alienation. In this particular case, the record indicates that Gottlieb had previously testified as a qualified expert in more than 100 cases. So you want this, if you're going to get an expert, you want somebody who's testified a bunch of cases. And this individual also had worked with 650 children who had experienced some degree of parental alienation. So we have a lot of experience here, which is credible. Despite failing to interview father or child, which is sort of interesting. In this case, the child's 15 years old. Gottlieb obtained extensive knowledge of the child's specific circumstances based on a review of the following items, hundreds of texts and emails. So again, texts and emails can be important between father, mother, and child, numerous videos of father, mother, and child interacting, and a psychological evaluation of child. In this particular case, pretty egregious facts, but from the time child was 6 months old to the present, father repeatedly called mother names in front of the child, like psycho, crazy, Satan, and the evil one. Obviously very bad. Father admitted to sending mother texts and emails in which called her vile names. However, he justified it by saying the child couldn't see the comments. But again, a very specific example of text and emails being used to show parental alienation. All right, admissibility of evidence and expert testimony of overcoming the top challenges is next up. Again, experts are going to be important. Again, psychologists, think about physicians or other medical experts as well, particularly if we're talking about physical abuse. They can either prove or disprove it. An expert witness must be informed of his or her duties in a conference where both parties are given the opportunity to participate. And then while preparing for trial, an expert hired by one party will often be deposed by the opposing party. In some of these cases, you could have two custody evaluations taking place. Mother could hire one, father could hire one, let's say. I've seen that in some murder cases and then the reports can become quite different. Expert opinions are admissible in the court, obviously, where they have, they're able to give an opinion testimony about whether there's parental alienation, whether it's realistic estrangement, whether none of it exists, and what would be in the best interest of the kids in terms of custody in light of that. I know many family law attorneys don't like expert witnesses. They have a hard time embracing this. Oftentimes clients don't want to embrace it either. Maybe they don't want to pay for it. But truly, if an individual is looking to prove or disprove alienation, an expert testimony can be a big, big key and is very important. And so make sure you explain that to your client. Again, many judges will be reluctant to grant custody evaluations. I don't know why. I mean, I have seen more and more judges who just think we don't need this. I can assess this as GAL. But again, without expert testimony, whether it's alienation or estrangement, or whether maybe the kid's just allied with one parent, so neither is there, can be very hard to distinguish. And so expert testimony, very, very important. Abuse can be hard to prove because oftentimes, there's nobody else there when the abuse occurs. So it's a lot of he said, she said, and maybe the kids recant their statements or something like that. So expert testimony can be important there as well to determine whether the abuse actually happened or didn't happen. Mental health professionals can be utilized too. So they can be really useful, and they can provide services in a confidential manner. And oftentimes, again, mental health professionals, they provide just therapy to parties. It's not to be used in court, but sometimes, obviously, they can be hired and they can be used in a case. And so mental health professionals could be important in these cases. I've seen lots of counselors come into court and testify, maybe counselors for the kids, counselors for the parties. Obviously, you get into this concept of a hired gun or whatnot. So some mental health experts get hired, they get used on these cases quite regularly. In theory, they could be viewed as a hired gun, but oftentimes, again, they can be very helpful because they're used to testifying in court. They know how court operates. They know what the legal standards are. And oftentimes a mental health professional can be jointly retained by the parties, like a custody evaluation, so they're court appointed, or maybe the guardian ad litem wants the assistance of a custody evaluator or mental health professional as well. So the court appointment piece can be huge, can be a big key. Obviously, judges have to decide cases based on the best interest of the kids, and that's a key. But one of the best ways to prepare for examining another party's expert in a custody case is to have an expert brief the attorney on the substantive areas of inquiry and point out what the opposing party should be asked about. So, it could be you have a joint custody evaluation, but you could have somebody else review the report if it's not favorable to your client, and that individual could point out discrepancies or maybe things about the report that could be called into question. In preparing an expert witness for direct examination, obviously, so if you're going to call an expert witness, it's imperative to prepare the expert on all the substantive issues, prepare them for how questions are going to be asked. Obviously, if they've testified a lot, they're going to know this more, but it's important to go through this with them. Anytime I've called a mental health expert in trial, I would normally provide them my questions in advance, and then if they thought I needed to ask something else or maybe take certain questions out, then they could work with me on that. So that can be a big key as well. And then explaining to them what they need to prove, what's needed, can be a big key as well. Obviously, if they've been in court a lot, they're going to kind of get this. When it comes to cross-examining a witness, the most important thing is preparation. Obviously, you got to know if you're going to cross an expert. They're going to know more about their field and their report than you are. And so you want to prepare in advance. One of the best ways to do it is obviously depose them in advance of the trial, and then take their depo answers and try to construct it into a cross-examination. And you can get into all kinds of issues in terms of their experience, what they relied upon, what their rationales are. Obviously, if any biases they have, or if they were dishonest about anything, maybe they didn't score a psychological test correctly, something like that. But you definitely want to depose them in advance. All right. And in terms of witness examination, some key questions to ask. And again, I'm just going to give you some examples here, but obviously, in most family law cases, kids, don't testify, but I've seen it happen a lot. Typically, the older the kids get to be. And so you got to know the rules in your jurisdiction in terms of whether kids are allowed to testify or not. Again, we talked before about not leading kids, asking them open-ended questions, these kinds of things. That can be a key if they're in the courtroom testifying. Ask open-ended questions. Don't try to lead them or trick them or confuse them. Obviously, a lot of the questions go back to those symptoms of parental alienation we talked about at the beginning, and see if you can ask questions that sort of broadly get to that. Again, keep in mind, common symptoms of parental alienation is a refusal to visit the other parent without reason, allowing children to choose whether or not to visit a parent, even though the court is not to make that choice, right? So the other parents say you don't have to go if you don't want. Telling the children about why the marriage failed. I mean, these are things that kids should know about. So if the kids know about these things, that's bad. If they know their other parent cheated or did X, Y, and Z during the marriage, that's not good. Common symptoms of parental alienation in children, again, include a relentless hatred for the targeted parent, parroting, or holding delusional or irrational beliefs. And so asking questions that sort of broadly get into this can be a big key, obviously. And again, kids should know certain things that are adult things. And if the kids know these things, that's not good, all right? But that gets us to the end. I did want to leave a couple minutes for questions. I think, yeah, we got about a couple minutes to spare, a few minutes to spare, but that's my presentation. I appreciate y'all coming on. And again, I'm glad to take any questions y'all have. Are these questions going to be typed in here, or are you going to read them to me, or how's that going to work? Okay, I see some of them. I see some of them typed here at the bottom. I got you. Okay. Okay. Well, one of them is, will you address why more parental alienation is brought up when there's a history of domestic violence? Is one of the questions I see. Um, well, it's a good question, and obviously there can be domestic violence that takes place, and there's no parental alienation at all, right? I mean, there's just violence. One of the parents is a bad actor or actress, and they've engaged in abuse and violence. But you just have to know, in doing this long enough, the comeback of the parent who's being accused is often, no, I didn't do those things. I didn't do any of that. I didn't engage in any of that violence or any of that emotional abuse or any of it. And the kids are saying I did these things because they've been alienated from me. So again, it doesn't have to come up in a domestic violence case, but far too often it does. That's the defense. That's the retort, and that's this presentation on facing false accusations head on. And so, you just know that becomes part and parcel of it. And again, it's just the common retort. That's why it comes up so much, because it's just that's the kind of the common response back. Let's see what we got here. He says, what would you say beyond testimony from material lay witnesses is the most important piece of evidence to convince magistrates of the existence of parental alienation? Many magistrates in my jurisdiction are not receptive to this idea or concept. I mean, again, I think I said this throughout the presentation, but I think the most important piece to prove is that you have a custody evaluation through an expert who testifies that there is parental alienation. I mean, to me, that's the most convincing and persuasive piece. I agree with you. A lot of judges aren't receptive to it, and obviously, from my experience, I've seen some judges who don't like custody evaluations. They don't think it's needed. They think they can weigh the evidence and the guardian items enough, and why do we have to do all of that? But again, from my vantage point, it is really hard to differentiate out of the gates. And I think I've never been a judge, but I would think it would be difficult to determine, is this alienation? Is this estrangement? Is this none of this? Is this just a kid, having a preference for one parent? But it's not alienation at all. At times, the lines might not be that clear. And so to me, the custody evaluator is the big piece. And again, hopefully, you're able to get the custody evaluation. And again, hopefully, as attorneys, we use folks who are experienced and have done lots of these in the past. But I think that's the big key from my vantage point to prove it. And my personal opinion is, without a custody evaluator, very hard to prove parental alienation at all. So if your client's insistent that it's happening, you've got to try to push the custody evaluation issue. And you all know the laws and rules in your jurisdiction in terms of, whether or not you're going to be able to get that or not. But that to me is a big piece. Let's see what we got here. Again, with lots of questions, I really appreciate it. What would you suggest to combat a claim of parental alienation where the children have alleged abuse, but the abuser was not found guilty in criminal court? Again, I think the custody evaluation is big key. Again, if psychologist says there's no alienation here. I think that would be a big key. And then, in terms of the abuse, again, obviously, this you get into a question. We talking emotional abuse? Are we talking physical abuse? Like what's being alleged here? But in terms of physical abuse, again, I've just seen cases where there's all these allegations of physical abuse, but then there's nothing there to prove it. You know what I mean? There's no photos, there's no evidence of bruises, or kids didn't go to the ER, they weren't injured. So I think the lack of evidence of physical abuse, and then in terms of emotional abuse, obviously these counseling records, these kinds of things, mental health records, a lot of that could be used too to prove or to combat a claim of parental alienation, because oftentimes, again, the kids love the other parent. The kids want to be around the other parent. It's not their preferred parent. And again, it's not fun to be a parent on the short end of that, but like that's not alienation, or doesn't on the surface would appear to be alienation. If they still want to see the other parent, kids probably haven't been alienated, and oftentimes you can glean that from records or whatnot. Let's see. If an expert has not interviewed both parents, what opinion could they give on alienation? Well, there's that one case I gave you in the section on social media and text evidence, and it's that expert Gottlieb, who they tried to strike as an expert from reading the case. The person got to testify as an expert because they've done a bunch of parental alienation cases, and that expert didn't interview either. But my recollection of that case is they based a lot of it on the text evidence and the email evidence, where the father is just saying terrible things about mom. And so, it's possible. It happened in that case. Obviously, I think as attorneys, we all would agree it's better for the expert to interview the parents of the kids. It's normally a mistake not to do that, but that's an example there where it didn't happen and it was enough. So obviously it's possible, but obviously I think we all would agree it's preferred. All right, we got time for a couple more questions here. And again, it says, is alienation a jury question? A jury trial is a legal determination by court. Well, obviously that's going to depend on the jurisdiction you're in. Where I do family law, I mean, I'm licensed in Missouri, Illinois, and Kansas, and the vast majority of my practice has been Missouri throughout my career, and we don't do juries in family law cases, and I assume that's the case for most of you all. And so, if you're in a jurisdiction like mine, that would be a determination by the court. If you're in a jurisdiction that allows jury trials in family law cases, I mean, I've heard of like maybe Georgia used to allow it, or maybe they still do. I'm not licensed there. Then maybe that would be a jury determination, but typically that would be a question for the judge to make the determination on. Am I at my time, and do I have time for any more questions? And again, thanks for all the questions and coming on. I really appreciate it. One more question. All right. What do we got here? What would you say if the child refuses to visit father because father lives in a separate house, have constant arguments, and she expressed fear that will become physical one day? She also has a diary where she documents all this. I mean, well, again, this is very fact specific, and obviously every case is going to be a little bit different. But obviously, I think as attorneys, don't we all have to tell our clients to abide by court orders? I mean, I think as lawyers, if there's a court order and if the other parent, the father has visits and it's court ordered, we have to tell our clients to abide by it. And from my vantage point, if it's so bad that our client feels like they cannot do it, I mean, typically, you file a restraining order, you file a child protective order, a modification, something to undo that order. I mean, typically, if your client just doesn't abide by the order, they risk being held in contempt. Now, I know there's certain cases, obviously, where the court doesn't hold somebody in contempt based on the facts being extreme, but I mean, typically, I think speculating that abuse might occur probably isn't enough. I mean, if a party is going to violate a court order, which is almost always a bad idea, there better be real abuse going on. Speculating that it may occur, from my vantage point, is probably not going to be enough. And so I think as lawyers, our advice always has to be abide by court orders, and if our client doesn't like the court order, let's seek to amend it or stay it somehow versus just not abiding by the court order. I think that's my one more question. Lots of good questions. I'd love to take more, but I think I'm at my time. But I appreciate you all coming on.
All right. Well, that is it for today. I want to thank everyone for who was participating, and I also want to thank our speaker for his time. We appreciate your attendance today and value your feedback. Please tell us how we did. Click the link now appearing on your screen to complete the survey, the certification process. If you do not click the link and complete the certification process now, you will receive an email with the link to complete the certification process within 24 hours. Thank you. We hope you've enjoyed our webinar. If your questions were not answered, you may email them directly to our presenters. Their email addresses are included in the presentation materials. Today's participants can order a recorded version of this event at a special attendee price. Please call Stratford Customer Service or visit Stratford's website at www.stratfordpub.com. And for live, unlimited webinars and recordings, try one of Stratford's annual passes. Simply respond to the email you will receive after the program. Stratford would like to thank you for your attendance. To end this webinar, simply close your browser. Thank you and goodbye.